concerns, perhaps yours, we're going to be discussing right here on Liberia in the Morning. Today's conversation in our studio discussing is
Senator Ibrahim Darius Dillon, Senator of Montserrat County. Mr. Senator, good morning and welcome.
Good morning, and thank you for the invitation. It's always good to be home.
Great.
At Radio Pujol 98.1.
98.1.
Yeah.
you look right there and you see.
More than that, who are in content as a board chair.
As a board chair, yeah. But you know, board chair is overwhelmed.
I know that one has social content. But let me say good morning to listeners on Radio Bourgeois 98.1 across the country, and those following on the social media on my page and one or two other social media pages like CDN News and the Senate page. Thank you for the invitation. I'm here.
Great. Mr. Senator, often you are a vocal voice and very forward writing on issues of national concern. But it seems your pen has been leaking a lot of ink in recent days with what many would now consider as the Yeke Koruba soap opera. Just this morning, you talk about 10 lawyers who have different interpretations.
Interpretation could vary.
Yeah, of an issue of law that is in plain text. And that is why, by your argument, ultimately it is the Supreme Court's ruling that should be considered. Now, what does this say about the complexity of our legal system vis-a-vis the ongoing soap opera with Yeke Koruba, Representative Yeke Koruba?
Well, once again, thank you for the invitation. The President of Liberia, consistent with the authority granted the President by the Constitution and under the Constitution, recalled the legislature to a 10-day working special session to primarily authorize the printing of additional, not new currency, but additional Liberian dollar.
Okay.
79 billion. And to consider the passage of a supplemental budget of $45 million. And to act upon other matters of national emergency in the 10 days. It is very likely that the Senate will today hold public hearings with the Central Bank of Liberia to justify why the legislature should authorize the printing of additional Liberian banknotes in the volume of 79 billion, not million, 79 billion. That should double the current quantum of money printed since the founding of Liberia. Because in 2021, the legislature authorized the printing of 48 billion Liberian dollars. And that was, I think, the highest so far at the time. Should we authorize this request for 79 billion, in effect, will be like doubling that amount. That will be adding onto the 48 billion, even though some
Mutilated
have
already.
mutilated and discarded already. So today the Senate will be doing a public hearing, very likely with the Central Bank, and the Ways and Means Committee, jointly with the Public Accounts Committee of the Senate. They are doing committee work on the budget, the draft budget of $45 million. $45 million is in addition to the $1.2 billion budget that is already current. The president has made some requests in the draft budget for the $45 million. I, along with I believe most of my colleagues, we are more keen on the what is projected for the army.
Okay.
We are considering increasing the amount for the army. When something happens to your country, in your country, there's always some good in some bad.
Yeah.
What is happening at the border with Liberia and Guinea is an eye-opener, should be a wake-up call for us in national leadership to come to the defense of the country. And so we have spoken among ourselves, and we are determined, and now, let me say hopefully, that this $45 million supplemental budget, the 600,000 projected for the army for recruitment, we are concluding to increase that amount, hopefully to anything around 5 million.
It's a big leap.
The reason is because it's easier to call for recruitment of additional people in the army. When you recruit people in the army and enlist them or enroll them into the army, they don't go back to their homes in the communities to live. Every one person you recruit in the army, they go to the barrack. So that means we need to improve on the barracks and do additional housing projects. Even if we don't do all this here, while we're recruiting additional people, while they're undergoing the recruitment exercises, we should start to prepare the housing facilities for them. And I know for a fact that, and people who know, the strength of an army is not just the number of persons in the army. You can enlist everybody, the entire population of Liberia that is of age, enlist all of us in the army. If there is no logistics,
Yeah. The sophistication of them.
forget it. And in this modern day and age, you need technology,
Right.
intelligence, your arsenal, not a football team now.
I'm struggling.
not a football team. The kind of weapons, military grade weapons that you have. How strong is your naval force? Do you have an air force? We are a country that don't even have a presidential jet. We don't even have a helicopter for our army, our police. You know, all these things. I know somebody following now, the first thing they will say, you reduce your pay. So we can borrow things. Everything that's shot in the country, the law make us pay. And you know, we must be reduced to 75. I can understand that other aspect. But we gotta be serious. I wanted to lay this business so that people understand that these 10 days the president called us for, it's a serious matter. Most especially at the Senate. So we are considering the army under this $45 million supplemental budget, meaning the $45 million added on the $1.2 billion budget that is already correct.
Now, you laid that out very well in the interest of national defense and the interest of the army. How informed is your proposal in the context of the people who lead the army, who lead national defense? Have you tied into their need list? Probably they have a strategic direction, and then you are all informed as you project.
So the fact that I'm talking about these things like housing, logistics, you know, military grade weapons and all this stuff should suggest that. In fact, I am a member of the
The
Defense
Defense Committee.
and Security and Intelligence Committee of the Senate. And so that there are some security information, it is very irresponsible to put on a microphone. You know, there are some information that are very classified. And as a responsible national leader, especially sitting on the committee that informs me daily of security and intelligence, you know, of the country, security and intelligence of the country, and the state of the security of the country. It is irresponsible to just be that version. But what is publicly known and what the public need to know and understand, it is responsible also to let them know.
Yeah.
So when you, I have to say this thing so you know that the increase could be or is justified. Should we do that increase? The army need over $100+ million. I mean, if we must get our army to where it is, every year we must be intentional about recruiting and then preparing that after recruiting, these people have decent place to live and they are equipped with the technology, with the intelligence, with the kind of weapons that they just having those kind of things can even scare your neighbor. Say, don't try to people.
So now you're on Defense Committee in the Senate. Before I go to my colleague, and then you're also on foreign. In fact, you chair Foreign Affairs. That leads me to finding out how improved is our relations with Guinea. I know we're cool with Sierra Leone because just the other day our president and the couple of government officials were alongside the border of Sierra Leone. But could you give us an update on what's transpiring at the border, and then probably relations with Guinea?
So I won't go deep. But the situation at the border, we still have our eyes at the border. We are thankful for wisdom of the president and the National Security, the Joint Security Commission. The Joint Security Commission comprises, of course, the security institutions and some relevant entities of government like the Ministry of Finance, the Foreign Ministry, and I won't name all, but we are thankful for wisdom of the president who chairs the Security Commission of our country for diplomacy. It is because of wisdom and diplomacy that one Liberian or Guinean has not died as a result of exchange of bullets at the border. And as much as it is discomforting and unacceptable for Guinean soldiers to be on our soil all this time, you will realize that even the number that were deployed from Guinea has drastically reduced. And with time, they will go back. We are working within the sub-region, within the Mano region, within the Mano River Union, with ECOWAS, AU, and don't forget, we are seated on the Security Council of the UN, where we have voting right. Normally, when people hear non-permanent member of the Security Council, the tendency to downplay it from lack of understanding of the importance of being in the Security Council. Non-permanent members simply means the city occupying is rotational every 2 years. That's what makes it non-permanent. The permanent members are the 5 voting veto members. There are 9 other countries, including Liberia, that make up the 15 membership of the Security Council. For the Security Council resolution to deploy UN peacekeeper anywhere, for humanitarian intervention by UN anywhere, to condemn human rights issue anywhere by the Security Council, you need 9 votes or more. Once you have 9 votes, so if the 5 permanent members vote, that vote is still not carried until 4
Additional
non-permanent members vote. Or all. But once you have 9, including 5, at most 4 of the
permanent members.
So Liberia has vote on the Security Council. The only difference is that the 5 permanent members, any of them or all of them can veto. Liberia can veto because we are non-member. But the fact that you can vote, you are as important on the Security Council. So Liberia is on the Security Council to determine peace, justice, respect for the rule of law, human rights around the world, humanitarian interventions around the world. So when you sit in high position to say to whom much is given,
Much is expected.
much is expected. So we're taking advantage of all of these leverages that we have. And we believe that it is working. It may be slow to the discomfort of ourselves as a country and our people, understandably, but it is working. And pretty soon, this matter will be laid to rest.
Mr. Senator, you pushing for an increase in the budget for the military, and you highlighted, for instance, the situation at the border, bringing that into sharper focus. But beyond that, there are those who are not just arguing for an increment, as much as they are arguing for that, they're also arguing for increment power, but are calling for a slant in the age, not the age requirement, the education requirement. Some are saying at least you should have 6th grade student rather than the regular high school students. But there are those who counter such an argument that, look, the history of the AFL as a belligerent force in the Civil War was largely contributed due to because of its low literacy rate at the time. Do you support, CORE at this time for a reduction in the education requirement for recruitment in the AFL?
Well, I'm going to get myself in trouble, but no, I don't. You know, when this thing happened at the border, when national leadership for that purpose, it is not enrollment, it is conscription. You are conscripting people in the army for a particular cause. But to have a standard army, people, literacy simply means once you can write and read and understand, comprehend what you read, with good comprehension, you are literate.
Actually, numeracy and literacy.
Yeah.
Right.
Yeah. You're talking about, I think we need to do a bit more on this. We'll leave from there, but the rehabilitation as part of this funding, rehabilitation of infrastructure in the barracks.
Yes.
Are you talking about across the county military facilities that have been down, rehabilitating them, or are you just talking about the EBK, the Camware, or the Coast Guard base?
Even the places that the current facilities where some of the army people live, we need to upgrade. And for instance, the army just took possession of the 72nd barracks. It is time now for us to be deliberate to move those people from over there that want them. It's an opportunity now to also go to 72nd. While we're recruiting, if the army has not sourced for the housing facility at 72nd, it's an opportunity. So this $45 million supplemental budget, we are pushing for the army, because the 2026 budget current of 1.2 billion, the army has about 18 million. We want to add, or we are pushing to add at least 4 or 5 million addition to that, so that this $4 to $5 million that we may push, and hopefully if we get it, it will go toward preparing the army for recruitment. While they're doing recruitment, they can start to prepare, logistics and housing for those that will be recruited and those who are already there.
Now let's stay right within the Senate and look at concessions. There is this very vibrant and vocal call for us or for the legislators to do better hygiene with concessions, MDAs and all of that. Because, as you know, argument flagged is, look, too much wealth for poor people. And then your colleague, Vapla, Senator Vapla of Grand Cayman County was just here the other day,
Yes.
passionately pleading for that. She's already submitted a letter. She submitted her voice as an update to the call. Having experienced Vice President visit to be mounting mining company specifically. This is not far from some of the things you advocate for, especially labor and all that. What is the update? What are you guys doing about that? Is there going to be a succinct and direct decision before you take a recess?
Regarding concessions, we have up to Thursday this week, day after tomorrow, to conclude on the 10 days the president called us back for.
Right.
So I'm not going to elevate the hope of the people that we can do something with concession in the next 2 days.
Why?
Because it is not practical. If I do that, it will be a political statement to elevate the hope of the people for nothing.
Is it an elaborate exercise?
So we can call for review.
Right.
Review.
Is it legal?
We can call for review. At the last time I was here or on another station, I said termination of a concession agreement is enshrined in the concession agreement. There's something in the law called significant non-performance. Once a concession or a concessionaire fails to perform significantly on the contract, on the terms of the contract that grounds for cancellation or termination. But in the very concession agreement, termination can be by mutual consent. It can be by arbitration in or other liability as determined in the concession agreement, or it can be by cancellation in the code of law for fraud determined in the concession or by the concession. You understand? Review of concession, general review. It got time placed in the concession. Normally, sometimes every 5 years or so. So to call for the review of the concession is one thing. For the review to take place is not normally at the legislature. It's with the executive.
The executive.
Yeah.
Now, so how would you, by the way, begin? Would there be something that precedes your probe? There's an assessment to sort of establish significant, non-performance or the otherwise?
So, if the concessionaire is supposed to pay taxes and they have not paid taxes over the period, you could take them to court first for evasion of taxes. If they're supposed to do social development funding and they are not paying it, it's a significant non-performance. There are several things that they must do or not do, fail to do, that determines significant non-performance.
Okay, so I think...
But you can't cancel unless it is expressly written in the contract that the road going to the concession, they should fix it. You can't cancel the contract because they fix the road, they're paying the taxes, which are to fix the road. You understand? So, on not fixing the road, which is not the obligation unless they choose to do it, Once they're paying the taxes, we sort of fix the road.
And
But
some of
if
the
it
things
is
I'm
in,
hearing,
if
some of the
it is
things
in
I'm
the
hearing,
contract that they sort of do the road and they don't do the road, then you can that can also constitute significant non-performance.
some of the contentions, what placed in the MDA will be so negligible, what is what in the MDA. So perhaps the companies may be living up to what's required. It's just that they may be too small to make the impact. Is there anything done about that? Anything could be done about that?
Look, I appreciate the eye opener on B Mountain. But I said, what's happening at B Mountain is nothing new.
Yeah, sure.
Let's fix it. We shouldn't make it look like as something new discovery. It's not no new discovery. B Mountain came to Liberia in 2001 under President Taylor. B Mountain became a legally existing company in Liberia 2001 under President Taylor. Understandably, under President Taylor, Liberia was at a disadvantage because when the environment is not conducive, look, I got one common saying that good morning is afraid of bad environment.
Right.
Good morning. Anytime you see
The morning like noise.
good morning is afraid of bad environment, especially when the environment is insecure. Anytime you see plenty of money pouring somewhere when the environment is insecure, that bad money. Money laundering, all that
flow.
all that kind of thing. So, under a democratic government of President Taylor after his election, Liberia under President Taylor was looking for concession. One concession to kind of Liberia, when you attract one investment concession, it likelihood it can, attract other people. So when you're coming from war, your country is not secure, insurance risk high, for doing business.
They put you at a disadvantage.
They put you, the country, at a disadvantage with the company that want to take the risk to come here. So our mining law says royalty on mineral, extracted mineral. Royalty for the government is 3%, not less than 3%, and not more than 10%. President Taylor, government knew that the company could say that place not secure, so I'm not coming. So they're backing for the lowest 3%. Probably if the law has said below 3%, maybe the Taylor government would have even backing for below 3%. But 3% was the floor and not more than 10% the ceiling when it comes to royalty. So the contract in 2001 with B Mountain was done on 3%. When Madam Salif came, they did a review and restatement of that contract and ratified it in 2013. 14, 15 years. That was supposed to end 2029, 2030.
Right.
But in 2023, 2 months to the presidential election, President Weah asked the legislature to ratify B Mountain, extending B Mountain by 25 years. By that time, and it's not about self-glorification, we were in the Senate by that time. We said no. 2 months to election, if you show you win the election, all this contract, when you win, you have time enough, to reasonably go through the contract with due diligence in the interest of the country. Why are you rushing? Or if another party wins, they will have the opportunity to sit with B Mountain to review and negotiate on current terms and reality. But at that time, it didn't make sense to majority of our colleagues. And in 2023, the legislature ratified. But I want to state something on the microphone. The legislature takes the beating, I can always understand. And I can understand why. And I don't get angry or feel about this stuff. The executive has years, months, days to enter into contract, negotiate terms and conditions The executive will take someone 1 year back and forth with any investment, company that want to do business in Liberia. Terms and condition. You do this. Our law says you are obligated to this other law. They got months and years. When they finish going with all that back and forth, doing draft, correcting draft, and coming back, reconsidering some things, changing things, everything, then they bring it to the legislature. Then sometimes the legislature get 1 week, 2 weeks. Then the very public, because sometimes the concession agreement say, if the agreement is ratified and become law in Liberia, the concession will provide 2,000 jobs. They will pay the amount in taxes. They will pay the amount in royalty. Then sometimes the legislature now either feel rushed or it's rushed, both by the executive and public outcry, because the public too believe there's something inside there for them, job opportunity. You understand? But I don't think we should allow ourselves to be rushed. That is why we take the beating. That's why the public don't care for how long that agreement stay with them. And when the document comes to the legislature for ratification is simply attestation. And approving something. You're agreeing with something. Something that's being signed by two parties, the executive and our company. The legislature can't change anything in a contract for ratification. You either vote yes and agree to everything, or you don't agree to some, or you vote no and send it back. With everything you disagree with, you send it back. The legislature got no authority to change anything in a contract, concession agreement. So it's either a vote yes, as it is, or vote no, and you note why you voted no, and send it back to the executive and that company to see whether it's possible for them to make changes and send it back. It's just a 2 persons enter into an agreement to lease one apartment, and they ask you to witness the document. You can't change anything. You want witness that document so that you can serve as witness to that lease agreement, so that when time comes and they need somebody who ain't no witnesses, you're there. So the legislature is more like an attestation. I'm not saying this to take the legislature off its responsibility. It will take courage, spine, and will to say no, the other one is not good. In majority, we say no, we're sending it back. But once we pass it, then we clean it. And when we pass it, we ratify it, we send it to the executive. The president still has to approve it and publish it before it becomes an enforceable law in the country. So in the case of B. Martin, we made the case for us not to give B. Martin 25 years in 2023. We should wait. If President we are one, he will have had the opportunity to sit down now and with time in his favor.
Yeah.
If we are one, with B. Martin contract ending in 2029, and we want and talk over in 2024, we will have sufficiency of time, understand, to go over B. Martin stuff, to correct some of the things, some of the discovery that was made this few days that is not new.
So you're listening to Radio Bushel in the morning, and today's conversation points at Montserrat County Senator Abraham Darius Dillon. We're going to take your calls and exclusively put you 15 minutes to the end of the program. So you put all your calls and then he responds to those concerns, and we call it a day. But as it is, we're still expanding and discussing, bringing new materials on the table. Now, Senator, at this moment, I think we've done significant justice with the Senate.
Yeah, yes. You want to go to politics.
Yes. So yes.
Let's put a spotlight on the constitutionality of what's transpired at the House of Representatives. So yes.
Yes. Before we go into some of the arguments, well, I mean, you talk about what is being put forward by the executive, the budget during the special sitting of the legislature. And in order for you to achieve your goal, you need a concurrence of the House of Representatives.
Correct.
In the midst of what is unfolding now in this Yeke quagmire or Yeke soap opera, how is it impacting on the achievement of the goal of concurrence?
The House is still functional. The Senate as well. I know you guys want to talk about a Yeke. So I'm not talking about Yeke. I want to stick to the issue.
We're interested in the issue. Yeah.
Yeah. Even though Yeke could be a subject, but the issue. In a society that doesn't have checkpoint where the law stops and where the law must be respected, that society cannot thrive, especially in any democracy and good governance. There's always a place where the law has checkpoint, buster. So the budget will pass if the House and the Senate agree, or the president will extend if the time is short, or we'll go and come back for our regular session in May and have time enough to look at the budget. But I don't know which representative or senator would not want us to increase and improve on the AFF budget for recruitment and empowerment, including the likelihood of not just recruiting people and not just preparing housing facility and logistics, also their own pay, their incentive as well. Their incentive as well is a motivational aspect that we must look at. So the $45 million supplemental budget, I don't think we should make a big deal out of it. Just add money to, add sufficient money to AFL, already $45 million, and we move. That's where my focus is. And from as far as I know, most of my colleagues in the Senate, that's where our focus is. So what's happening in the House is still functional.
So, what's your take on everything happening?
My take is for the respect for the rule of law. Look, I worked at Justice Ministry for 11 years. Out of the 11 years, 9 years, I was special assistant to the Solicitor General. I served 6 Solicitor Generals. Solicitor General, 6 of them. And I served 6 Ministers of Justice during my tenure at the Justice Ministry. The Ministry of Justice is almost like the law firm of the government. Our business to go to court, represent government, prosecute for crime, represent government in all cases to which the government is a party or agents of the government are parties there. At the Ministry of Justice, I was never a lawyer, but I was special assistant to the Solicitor General. And the office of the Solicitor General is the law chamber of the government. I learned a lot. I learned there a lot. So I'm a big respecter for the respect for the rule of law. So it's not about Yeke. It's about honoring what the law says. So let me hear your specific question on that.
Yeah, so specifically, where is the rule of law conflicted?
There's a principle in law that says what the law does not grant, it withholds. The thing the law does not grant you, ain't give it to you, that means the law is holding it. You can exercise that authority.
Let's apply that.
Okay, so Article 38 of the Constitution is like the power voice. If anybody in this studio listening by radio or following on social media believes, but before I say that, when I made reference to my being at Justice Ministry, I was trying to say something. You can go to court and win case by your feelings or sentiment. Nobody now go to court say I feel that they messed up for me. That feeling you carry to court, it can win. How you feel about a person, it can win case. Evidence proven beyond reasonable doubt, especially in criminal case. That one can win case. That one can convict people. Let me repeat. I know you're looking at your time. Myself will extend the time small. Because me, I like to converse, have that kind of conversation. Anytime people carry feelings to court, or partisan mandate, or how you feel about the person, or your sentiment perception, you can win case. That evidence. Article 38 of the Constitution, I know what you're getting here now.
Well,
I think I
fine.
need it.
Yeah.
I want you to please read it. Or let me try to read it for the second we try to interrogate.
Nobody says that thing nowadays.
No, I
man.
like it. You know when you talk about integrity, you know, before.
When you're reading the Prima Tupo.
Article 38 of the Constitution says, each house shall adopt its own rules of procedure, enforce order, and with the concurrence of 2/3 of the entire membership, may expel a member for cause. Each house shall establish its own committees and subcommittees, provided, however, that the committees on revenues and appropriation shall consist of one member from each county. Here is where I want to emphasize. All rules adopted by the legislature shall conform to the requirements of due process laid down in this Constitution. Many people pick up John 3:16 and they say, for God so loved the world that he sent his only begotten son. Period. And they're gone. That's not the full text of John 3:16. You got to conclude with that whosoever believeth in him shall not perish but have everlasting life. That is the full text of John 3:16. When you run with each house, the Constitution says the people can get their own rule. And you leave the very significant consequential part of Article 38, that all rules adopted by the legislature shall conform to the requirements of due process laid down in this Constitution. It says due process laid down in each house rule. Each house don't have their own due process.
So
The due process
due process is
must
dark.
conform to the requirements that laid down in this Constitution.
It's a
Mr.
Senator.
Senator,
What is due process?
So,
Yeah, we're coming there.
Mr. Senator, yes, maybe in two phases. What is due process? And in your estimation, what was accorded Representative Cordoba
Was one of due process?
was not a due process?
The court will determine that, but in my mundane view, no, due process was not accorded. Let me make it clear. I'm not here in defense of Yeke. The only thing I won't do, I got no moral standing to criticize Yeke for causing us. Because when Yeke was causing other people, we rewarded him with re-election. I got no moral standing. I didn't care to all one anger. But to deal with Yeke or anybody in the legislature, any lawmaker, relying that Article 38 that you rely on to do your own rule and enforce order, it gave you a consequential guidance. You must do it in keeping with due process. That is the due process that you determine, that the due process laid down in this Constitution. That's what Article 38 concludes with. And every time somebody, and due process is accorded when rights, fundamental and constitutional rights, will be affected. Due process begins with somebody who has right to liberty, right to property, right to life, right to a job, like a tenure elective job. To deprive that person of that right, there must be a complaint. There must be a complainant. There must be an identified accused person the complaint is against. The person must have right to be heard and represented by a lawyer. The person must be given notice, adequate notice. When the person comes with a lawyer, the lawyer must talk in representing them.
In the chambers.
In the chamber.
And not the court.
But that's what the Supreme Court said. Now, you see the reason I'm emphasizing on the closing part of Article 38. Anytime due process laid down in the Constitution is not followed, and you believe you are being injured by denial of that due process, well, please you can carry a complaint.
The Supreme Court.
Because only the Supreme Court can determine constitutional violation. Due process laid down in this Constitution, beginning with Article 20, how it is spelled out in Article 20 of the Constitution. The right to legal counsel, the right to be heard. A due process of law, in short, is the process that allows hearing before judgment. Normally, it's before condemnation, but it can also be acquitted, because after hearing, you can also be acquitted. So due process, in short, is the process that hears before it condemns. And I will add, before it acquits, where applicable. And when you feel that your due process entitlement right is not being accorded, the only place you can run to that is Supreme Court. When we're making law, say nobody should pass on Broad Street. We're making law. We're in a process of debating that law. You can't go to the court and ask the court to prohibit us from passing that law. The Supreme Court of Liberia, the Supreme Court of America, the Supreme Court of Great Britain, or anywhere where democracy and good governance is practiced, no Supreme Court can stop, prohibit the legislature or Congress or Parliament in the process of making law, just because somebody feels that that law is bad or will be bad. When we pass the law and you feel that that law injures you, then you take it to the court. The court will review, and when the court determines that that law is inconsistent, or portion of that law is inconsistent with the Constitution, then the Supreme Court invokes Article 2 of the Constitution to either declare that entire law or the portion that is inconsistent not involved. But our function to make law, the Supreme Court, no Supreme Court, any part of the world can prohibit the legislature or Parliament or Congress in the process of lawmaking. But when you want to do administrative disciplinary action on a member, or even holding somebody from outside with contempt, where you can fine them, you can send them to jail, where the liberty, constitutional, fundamental right to liberty, freedom will be affected, that person is entitled to due process of law. And that due process of law is not determined by the rules of the legislature.
It's determined by the Constitution.
It's determined by the Constitution.
Now you can,
no matter who feels affected, the place to run is to the court. That is why you see the court has never, in 2011, I'm not too sure at the time, 2010, Samuel Freeman, political leader of MPC, the Movement for Progressive Change, The legislature function is to set threshold after population settles. So it's a function of the legislature. The legislature was in the process of doing threshold. And Seaman Fremont ran to the Supreme Court for the Supreme Court to prohibit. The Supreme Court said, no, it's premature. That setting threshold is a constitutional function of the legislature. When they set a threshold and you feel that you are injured or wrong, or they did it the wrong way, then you can come for interpretation. Then we can strike it down or we can uphold it, depending on the evidence of the weight of the evidence you will bring. So, but the Supreme Court has the right with the authority to say the contempt you won't put on the person, the person said you're not giving them due process. So they came to us for us to review whether you're going by due process of law laid down in the Constitution. So you're holding yet. Let's review how you're going. If you're proceeding right, the Supreme Court cannot prohibit the legislature from holding people in contempt because it's a constitutional power granted by the Constitution. In short, the Supreme Court cannot declare unconstitutional what is constitutional. The Supreme Court can only interpret it. Once it is constitutional, the Supreme Court cannot abridge it. It cannot abrogate it. It cannot declare it null and void. A function of the legislature cannot be prohibited by the Supreme Court. But where rights, your right to job, your protection under the law will be affected, due process must be accorded, and that due process is determined by the Constitution. And who can interpret that due process? It's the Supreme Court.
Now you can call us on 0771-981-981. We now accommodate your calls. You can make your points. The only thing is you have to be succinct. You have to be short. You know, no commentary. Good morning. Good morning. What's the name? Take time. Hello, Mohammed. Yeah. Thank you so much. You too can call us on 0771-981-981. We note your question and you're going to get an answer. But another caller is on the line. Good morning. And where do you call us from? What's your name, please?
Thank you. My name is Pascal David.
Okay, Pascal.
Well, I heard the senator talking about due process and respect for the law. Senator Dillon, President Walker is on record for removing people from training positions and refusing to adhere to this message. Recent one was the case of Dr. Fred Young. This president has been used to raise the station to Fred Young. I mean, that has the legislature precisely is part of on the body. I mean, a fully youngest case, which you think also not being followed in terms of due process. That's a people I mean, issues with the president and respecting the law. Even with the issue of the political party member, he said he couldn't listen to the court for rather work with forum. I mean, right away, in terms of the partners of the senator.
Pascal, question, please.
Thank you. So we're still taking callers.
Yeah, we're still taking calls. Please call us on 0771-981-981. There is a person on the line. Good morning.
Good morning. My name is James Gatt, and I'm joining from around Freeport.
Please go ahead.
Senator is here. Senator, my concern has been due to one issue on our discussion this morning. concerning the army. You know, plenty people have dream or vision of becoming a military personnel. But the requirement, and if you look at our constitution, and I know what you people are doing to look at our constitution, because the higher ranking is still with the presidency, all the requirements, they don't talk anything about education. But when you join the army, if you talk about you must be a non-base student and you must be a high school graduate before you can join the army. Well, of becoming army, but they don't have the requirement. So, man, who goes to the army to sit down and free? How to shoot gun, how to fight war, that man needs ESC degree to get used to, huh?
So what do you think would be?
Don't require any education, only to be a resident.
Okay. So what would you prefer? No education?
No, the army is education for the requirement that people can be in the army, you have to speak. All people are in the military now, they are in the Bureau University.
What should be the threshold? Thank you so much for the support. Yes, you too can call us on. We have to lower the microphone.
The person will lower the volume.
Okay. Could you let the person go? Please, you have to walk away from whatever you're monitoring from. Good morning.
Yeah, good morning. How are you?
Yes, I'm fine. What's your name? Where do you call from? Please make your point quickly.
But sometimes it really makes sense to your public. Seriously, I've been following Senator Dillon saying they're going to make it about a lot of things. You know, but when the problem with Senator Dillon in the government, he's not standing with President Joseph Mabaka the way he's standing with President George Manneh Weah. Well, then, for me, as Senator Dillon, I want to remind you, you forget about the law minister. You forget about the way again. You have to go back there, and I told you the last time, a lot of people working in the private sector, they have to be connected with the legislature to inform our people in the legislature that representing your country and district to inform you people how the investor that you are bringing in the country, the way in which you are treating Nigerian people. Because the labor minister not seeking the word of the Nigerian people in the private sector specifically. And President Joseph Mabaka, the engine of the country, you see, one is the private sector. You see, if you hold the private sector properly, Senator Dillon,
Thank you so much. Thank you so much. Your point is taken. You don't find him as hard as he was in the previous government. A caller is there. Good morning. Good morning.
Thank you. My name is Francis Cotina, and I've been for the Ghana Electoral Center at the district.
Mama, put some life in your voice now.
They posted the microphone here was low.
Hello.
Yes?
When it comes to the issue of Nika Kuruba, so I think in school, and whatever is a due practice, but you're going to remain very much. I don't know how to classify it. If you see that is unconscionable and you cannot apologize for whatever statement it is, and I don't believe it that led to its expression. I think everyone needs to be serious. One of them is that it's going to be one vocal politician. Totally unacceptable. So I think the Nigerian legislature is a place of politics. Whatever you do there will be politicized. That is not a church, that is a political theater. So whatever they do will be politically driven.
Thank you so much. Thank you. Thank you so much. Yes, there is a female on the line there. I mean, let's encourage the female. Good morning. What's your name and where do you call from? Yes, Princess.
Calling from the Unity Party in Europe.
Yes, please make your point
snappy.
snappy.
I want to say good morning to Senator Taylor. Senator Taylor, my attention draws to the Yaka Koluba issue. My question is, will the court set Yaka Koluba free for threatening our nation? Because our party is not talking yet. Will the court set it free? And please, somebody make a statement. People were taken from their job yesterday, and people were replaced there. Thank you.
Thank you so much, Princess. You can call us on 0771 981 981. We're almost at 10 callers. Yes, good morning.
Yeah, good morning. Yes, good morning.
Yes, where do you call from? What's your name, please?
Yes, my name is Jackson. I'm calling from the manager.
Right, go ahead.
Firstly, let me appreciate all the Honorable Senators in the data. He has been very outspoken when it comes to issues in the country. I think it's not the law. He's a lawmaker who have a lot more discipline when it comes to national issues. And for him, he's a man of consensus. So I want to ask my question to the Senator. Honorable Senator, right now, if you look at the major battle in minority, that's what is vulnerable. If there's any amendment that can be passed by the House in order to adjust the major barriers that people cannot live around it, and also to the issue of the spending. I think for me it's possible to increase more allocation to the military, because other countries around the world have more budget for the military. It didn't come first. So it will be very, very important to increase. Hello?
Yeah, go ahead.
Yes. So it will be very important to increase our military or capability by buying some warfare and other material, also to train our military, because to train it will be important with the know on some issues, how to go on the front. But
Thank you so much. Thank you. We really just don't have the time. But your point is considered. He wants to see his military capacity increase. Another person there. Good morning. What's your name and where do you call from? Where do you call from? Good morning. Now, okay, we can stop this far. Barrage of questions.
Good morning.
Let's squeeze in this person. Good morning. You have to be very quick.
Good morning, our honorable senator in the studio, and good morning to our many listeners.
Let's know you. What's your name?
Good, thank you. Well, I'm Ramsey M. Joseph, and I'm going to join you from district number 5, Monterey County.
Yes.
Yeah, I want to ask my senator a question. Honorable Dillon, please make it clear to us the meaning of oath before any government official take of office according to our constitution. The oath to defend and to protect the land of Mama Liberia. That's one. Two, when Yeke made this statement, didn't he know that he went against the Liberian people with his due process, this and that, whatever? He didn't know that he needed due process for Liberian people when you are making this statement that our territory belongs to Guinea?
Thank you so much.
When he made that statement,
Thank
when
you.
last did any Guinea lawmaker ever said
He's concerned about the chemistry of what Honorable Yeke said, and not necessarily due process. Now, Senator, you heard the callers. I know you took note, but somebody's talking about comparing the previous legislature, 54th to 55th. You classified 55th as rubber, 54th as rubber stamped. Where is this one? What qualification do you give this one that you also serving? Why, what are we talking about due process and not the composition, the wound, purported wound committed by...
Okay, so I
think the senator...
You got a note, yeah.
So the thing is, I always tell us, all of us, we overly political in the country, all guilty. All the things I talk about the army, all the things I talk about printing money that will affect the economy. They put their all I didn't come here to defend Yeke.
Right, and I think it's going to be clear.
I made it very clear.
And social media is already awash with quotes from you on Yeke.
I didn't come here to defend Yeke. I came to speak to an issue, even though Yeke may be the subject of the issue. The issue is when we in the legislature or any administrative body develop the tendency not to honor the court, when a court is acting within the scope of its constitutional authority, it becomes troubling for any good citizen, whether you are a lawmaker like me or not. I get it saying that when a child wrongs you, sometimes the way you beating a child, some people can't even ask what the child did. They can start getting fed with you. What the child did, so when you beating him like that, they ignore the wrong the child did. If you overly, brutally, violently beating that child. So what am I saying in essence? We can't say Article 38 say we do our own rule and ignore the instruction for Article 38. No, we can't do that. We should never ever do that. Let me tell you what the Supreme Court said. I heard somebody talking about due process. And you know, when you are represented by a lawyer, anywhere fundamental or constitutional right will be affected. Yet what the Supreme Court said. In the Grace Pan case versus the House of Representatives, the very legislature, when Grace Pan lawyers went to the House, the House said, the lawyer can't talk here. They play here, we get our own rule. Due process, that's not the kind of due process that can be in the court. Lawyer can't talk here, you only here to guide your client. Grace Pan lawyers went to court on prohibition in the exercise against the House of Representatives in the exercise of its authority to hold people in contempt. Here's what the court said. The respondent House of Representatives, by disallowing Councilor Pearl Brown Bull, petitioner's legal counsel, from making statements in defense of her client, petitioner Grace T. Pan, at least, or by restricting counsel from speaking openly and unrestrictedly to the quasi-judicial setting in defense of her client, the accused stripped Grace Pan of her fundamental right. Proceedings conducted under circumstances tending not to afford an accused, as in the instant, full and adequate opportunity of legal representation. A decision concluded therefrom adjudging an accused guilty of legislative contempt, as well as the sanction imposed as a result, are untenable. That's what the Supreme Court said. Now, someone who listening, you know, will always get sentiment. Someone will say, oh, but our contempt case. This is the Supreme Court telling you what constitutes due process. Due process is giving somebody notice, adequate notice, and the person get a lawyer, they can ask for time to find a lawyer, and then when the lawyer comes, the Supreme Court has ruled. When the Supreme Court ruled, they both people call it precedent. The Supreme Court has settled. I was chief of staff to Edwin Snow when he was speaker in 2006. And obtained his forced resignation. But we went to the court. The full bench ruled and defined due process. And over now people, I can understand the politics. And I get what I do. I didn't come here for you to go back. I came here so we can continue doing this like this. You get your number, you get your cause, get a man due process. Kabina Janet, like it or not, that's a former associate justice. Kabina Janet was on that bench for years. They were giving ruling on due process. He knows what due process is. He was representing Yeke. He knows that as a lawyer, in any process, any hearing that has to do with rights, not our CEO, our GHTS, any constitutional or fundamental rights that will be affected. When a lawyer is represented, that lawyer must speak and represent that client unrestrictedly. That's not my word. That's the word of the Supreme Court. And that's not only the word of the Supreme Court, the opinion of the Supreme Court, and then the judgment ruling. So the court can get opinion, it can get ruling. The ruling, you follow it, that the ruling settles the matter. The Supreme Court ruling opinion was that when a lawyer is representing his client, whether it is in the legislature for contempt or expulsion or impeachment, whether it is at the labor ministry for labor-related cases before the hearing officer, whether it's before the election commission on election-related cases, the lawyer must speak unrestrictedly. That's what the Supreme Court said. Now, the Supreme Court can never say your money is fair, Yeke. It's not within the authority. The Constitution vests the authority with the House to expel any of its own. So the Supreme Court cannot cancel that decision. The Supreme Court can only review the processes leading to the decision and say, you're going to do it the right way. So I didn't come here to go put Yeke back in the house. Yeke not call all in the country. The only reason why I don't feel bad when Yeke causing us, because when you were causing other people, we were not there with him. We rewarded him with re-election. So me, I guess king to withstand you. And Yeke cause everybody, don't take everybody getting fair now. Anything you do, you always do it and catch up with you. So that Yeke on our own deeds, catching up with him. But I don't care how we angry at Yeke. Maturity, respect for the rule of law, good governance must obligate us to go by what the law says. So Yeke grandma over there, you know grandma over there. That's not my business. My business is it will continue to allow this bad precedent to take place within the right thing to do. And we must stop doing the wrong things and thinking that it is the right thing to do. That is my point. Let me conclude.
Before you conclude, just want to ask you quickly on the scene Yeke matter. Now that he's taking the road to the Supreme Court, do you consider this as a long-drawn process, or is it, what has happened to him has already happened?
Come again?
He has taken the road to the Supreme Court. Has his path to the Supreme Court created any opportunity for this to be a long-drawn process, a long haul like we had with the Fonati case?
There are sometimes you fight battles sometimes not to win the victory for yourself, but for posterity. People don't understand. So now some advocacy, some fight you get in, just know what you're fighting for. Sometimes it will not benefit you, but somebody else who that same thing may have happened to will benefit from the prevention of it happening to them. That will call posterity. So all I'm saying here is Yeke going before the court, and my experience in the legal practice, in the legal field, no court will take a case that the court does not have jurisdiction over. If I stole your $10 and you took me to the debt court, the court will say, no, go to the criminal court if I stole your $10. Because the debt court doesn't have jurisdiction over criminal matter. If the debt court hear that criminal case and declare me guilty, the Supreme Court can overturn it, because that is why in the law they call it the court of competent jurisdiction. That word is not there for nothing. The court of competent jurisdiction. If I owe you $20, you can take me to the criminal court, because owing you, which is a several issue of debt, is not a criminal matter to take to the criminal court. So it is a well-settled principle in any judicial function that any tribunal, administrative body, or court, before a hear a matter, before the court hears a matter, the court can ask itself one question first. Do I have jurisdiction over the matter? And once the court answers that question, then it can intervene. The Supreme Court, through the justice in Chima, has asked the House of Representatives to file their answer in 10 days. You know what that means? It means the court has satisfied that question. Do we have jurisdiction over the matter? The court has answered yes. So now it is exercising jurisdiction over that matter. Will the court say you go put Yeke back or force him back? No. The court will say the way you're moving, what the law says, that's how you're going to do it. You go back and do it the right way. It is not no guarantee that Yeke will go back. I didn't come here for Yeke to go back. I came here so that the record can be so clear now.
Thanks ever so much. And it's good for us to wrap this up. The Voice strong.